Hello, everybody. What are you doing? What a way to start the stream. Don't you touch those cat treats. Oh, you know it. You know it. Absolutely. Oh, I'm so excited. I had fun putting this one together. There. Oh, and before we begin, I have to do this. I saw the sweetest message from Chris Barton that said that they miss me saying hello to them. So, hello, Chris Barton. I also, oh my gosh, there's so many of you that I miss that I know you have lives, and I know you're there in the replay crew, Checks and Cherries and Thin as Seven. You still get in here every once in a while. Ruth Ward, sweetie, if you're still watching, I miss you and I love you. And Terry Barnes, he was here earlier today. You guys make my whole life. You guys are just the best. So let's give a big kiss to Ava. Thanks for that. Burped right in my face. All right. Hello, Sir Philip. Hello, Eileen E. Carlin. Linda Applegate, my love. Hello, Ginny. C-Rex, hello, sweetie pie. Oh, did I miss J-Bod? I didn't see J-Bod in here. Hold on, I gotta back it up. Beep, beep, beep. I don't see him. I'll find him. Hello, she's a maker. I did not hear that. Like a while ago, I know she was. Yeah. Oh, okay. I see the comment now. Yeah. So she was, and then she sued, and she ran for an office and won. Yeah. It was a wild ride. Hello, Eric Mings. Yes. Oh, CC Rex is just a wealth of information. Everybody's favorite paw pet. Hello, Catherine Gaston, my love. You can lurk away. Just lick that like button first. Sarah Oberlander, welcome. I'm so happy you made it. Oh, it's okay. You can't know everybody. She was the former prosecutor in Judge Middleton's court about, oh gosh, guys, what are we running? Like 6 months ago ish. And then there was a case where a defendant talked to a victim in the hallway, and she had no control over it, but all blame fell on her, and so she was fired for it. And it was a real toxic situation. But if you're a fan of Law Talk with Mike, she's the lady that does I know where there's free lodging. So if you've ever seen that clip on Law Talk with Mike, that is Debbie Davis. And she actually had or has a YouTube channel of her own. Is it Debbie Davis Speaks? I think. She's an awesome person. She really is. She's very compassionate. She's got goats. You gotta love someone with goats. So, tonight I found, I don't know if you remember, the other day I ran Zanny Joanne. We kind of stumbled upon her hearing, and it was a fantastic moment. And they had talked about her failing to appear, and I happened to find her lost episode where she failed to appear in front of Judge Ricky. So we're kind of, we watched her original stuff, and then we jumped forward, and now we're gonna skip back just a little bit. What? You're so spoiled. so spoiled. So that's what we're going to start with. And then we're from there. We've got a few hearings. We've got Judge Ricky. We've got Judge Crum. And then we go back to Judge Ricky, I think. And we have a girl who bawls her eyes out and screams. That's always fun. Yeah, but if what she says is true, I don't really blame her. The DA's office is messed up in Michigan right now. They couldn't keep prosecutors for a while. They struggled. Yeah, hello, K. John Boom. Back to the Future it is. I feel like Marty McFly myself. Hello, Fozzie in Texas. Oh, I'm so happy you're going to be here in any capacity. Ava, my goodness. You are being extra. What is up? How can I help you? I just had you in. Your nose is still cold. How can I help you? What can I do for the Ava? I'm waiting. What do you want? Do you gotta go potty again? You're crazy. You're kidding me. You gotta go outside? You gotta go potty? Oh my gosh. Okay, guys. I'm so sorry. I'm gonna put this on right away. And then I apparently need to tie someone out. Those treats got her. Moved through her like coffee, apparently. She's just keeping me on track. That's all it is.
This is in the District Court of Greenwood County, Kansas, case entitled State of Kansas versus Joanna Carson. It's case number 2024 CR 14. Chris Ambrose appears as defense counsel, Jill Gillette as prosecuting attorney. However, the defendant has not appeared. I will note that the matter was last before the court on October the 31st. At that time, the defendant appeared late that time. Defendant eventually pled guilty to count 1, Class B misdemeanor DUI, and count 2, possession of methamphetamine, a level 5 drug felony. The court ordered a pre-sentence report, ordered the defendant to comply with all assessments necessary for the pre-sentence process, and then set sentencing today, December 26th at 11 o'clock a.m. by Zoom, with the defendant required to appear at the Greenwood County Courthouse. At that time, the court had also set aside an order of bond forfeiture and bench warrant issued because of her late appearance. Mr. Ambrose, I trust you don't have an explanation as to why your client's not on the meeting right now?
Your Honor, I don't. I spoke with her this morning via telephone, and sounded like her plan was to be there at the courthouse. I'm unsure where she's at.
All right. I also will note that I received a report from Mr. Smith from Court Services of an incomplete pre-sentence investigation. In essence, as I understand it, that she had not completed the risk needs assessment, the WRNA. She also hadn't completed the substance abuse evaluation necessary for Senate Bill 123, determination of eligibility. Have I summarized that correctly, Mr. Smith?
Yes, Your Honor. And just to update the court so it has the most current information, I did receive an email from Community Corrections Officer Teresa Stanfield today saying that they had received a call from DECA in Pittsburgh saying that she has an appointment scheduled for an evaluation on Monday, December the 30th, apparently.
All right. What the court sees in this case is the defendant's just utter failure to comply with court-directed conditions. She had a bond reinstatement done last time. The court expected her, in fact, ordered her to do certain things. She hasn't done them, and she had 2 months to complete these. And court finds that the default is attributable solely to the defendant in this case. Further, the defendant has failed to appear for court today. So for 2 reasons, this court will enter an order of bond forfeiture and bench warrant, specifically for failure to appear on time for court today, and also because she has not complied with court-ordered conditions in relation to the pre-sentence investigation. So there are 2 separate distinct reasons why the defendant should not be under bond at this point. I'm going to order her to be under a no bond hold when picked up. Mr. Smith, let us presuppose she's going to be picked up relatively soon. Once picked up, how long will it take for you to complete your report? Just a reasonable estimate.
Your Honor, I believe 3 weeks would give me enough time to complete what I would need to have done. I have the sum and the substance of the criminal history gathered already. So it's simply getting the WRNA completed and also trying to get an evaluator to the jail to get that Senate Bill 123 SASE accomplished.
Okay. We have another date for Greenwood County cases on Thursday, January the 23rd. I'm going to go ahead and try to set a date on that calendar with the optimism that we'll be able to proceed on that date. Mandy, I see that we could do this at 2. Do you show that as well?
Yes, Judge.
Okay. 2 o'clock, Thursday, January 23 is reset for the Carson sentencing. Presupposing, of course, the pre-sentence process can be completed by then. If not, we'll do appropriate future scheduling at that time. Thursday, January 23, 2 o'clock is the reset sentencing date on Joanna Carson. Anything else at this time, Mr. Lett?
I can't think of anything else, Your Honor.
Mr. Ambrose?
Nothing for me, Judge. Thank you.
And at this time, the Joanna Carson matter will be in recess. This meeting may be ended for all. This is in the District Court of Butler County, Kansas, case entitled Lucas Johnson versus the Kansas Department of Revenue. And it's the only named defendant.
Z Auto, Your Honor.
Okay.
I guess you're right. The caption does not have that, although the summons did.
All right. Case number 2024 CV 161. Scott Reed appears with the Kansas Department of Revenue. Lucas Johnson, the plaintiff in the case, appears representing himself. Mr. Johnson, I'm trying to sort this out. You say in number 7 of your petition that you purchased the car from Kevin Burton, who passed away in February of 2023. So I trust you paid him money but didn't get a title back?
Correct. And I found out what happened. He got pulled over in the car, and he had the title with him, and he didn't get his property back from the jail, the Cedric County jail, and they threw it away. After 30 days, they threw his property that he had away. So the title ended up getting thrown away, the one that he'd had. And the original buyer of the car is a Hillary Bailey, was his stepdaughter.
Okay. So you're not sure exactly who the car was titled to at the time you bought it?
Yes, it was titled to Hillary Bailey.
Okay. Well, Hillary Bailey's not named as a defendant here. And why would Z Auto be involved in this?
Because the car still registered to them. She didn't have the car registered. She never had the car registered.
Okay.
So the car still registered to the Z Autos.
So Z Auto had it, and then Hillary Bailey bought it.
Yes.
Then you bought it from Kevin Burton
Correct.
for some reason rather than Hillary Bailey.
Well, she had sold it to Kevin, but Kevin didn't have it registered and hadn't had the title switched over into his name. And at the time, I didn't know this, and I thought he still had the title, but he didn't. He had gotten thrown away, like I said, when he got arrested in Wichita. So
when you paid the money, but you didn't at the same time expect a title in return?
Well, of course I did, but I didn't know that he didn't have it. I was still thinking he had it, and so did he. He didn't realize that it had got thrown away, that it was in his material, that it was in his belongings when he got arrested.
And if you think this is messy, just wait, it gets worse.
But you paid him anyway.
Yeah, I had already paid him. Yes.
Okay. Well, I'm just trying to sort out the paperwork here. It looks like that you may have sent or tried to send by certified mail to Z Auto.
Yes.
And you say that the return of summons is true and correct, but do you have a return certified mailing signed for by a representative of Z Auto?
No, I don't.
Okay, and why is that? Did you not get a certified mail return back?
No, I did not.
Okay, well, okay. So how did we verify that they actually received your attempted certified mail?
I'm not sure, Your Honor.
Okay, well, I'm not either. Likewise, I don't see that Hillary Bailey that you've attempted to serve her.
Yes, I have attempted to serve her. She is certified chronically insane, I guess, is what I've come to find out. I've tried dealing with her quite a few times, but to no resolve. Not that she wasn't willing to help. She wasn't able to, like, for instance, her license became expired and she wasn't able to even get an ID because she wasn't able to answer some questions her mother was telling me. So I've tried numerous times to get her to help, just to go to get the title, and just file for a lost one or whatnot. And we weren't able to accomplish that. So I figured the best next thing would just be try to get the title myself. So.
All right. Do you know if an estate was ever open for Kevin Burton?
I don't know.
Okay. All right, I see a return of service on summons/petition signed by a Wayne Beeman. Apparently it's for service that was on the Attorney General's office. Mr. Reed, was that the service that led to you being involved in this?
Yes, Your Honor. Since the Department of Revenue is a state agency, we are served by serving the Attorney General.
All right. That explains why you are here today.
So the car is actually owned by a crazy girl, but he bought it from a guy who went to jail, and the title that's in the crazy girl's name got thrown away in inmate's property, and then inmate passed away, and now the Kansas Department of Revenue is involved. Like, how many layers does this onion have?
All right, Mr. Johnson, court has to determined that there's at least been some bona fide attempt to notify and bring into this case all of the people that might be involved here. You haven't done any type of publication notice, I trust?
I have a certified mail. No, not with Hillary. So like I said, with no resolve from her, I couldn't get her to do anything. I couldn't even get her to leave the house to go back to the Z Autos when before they had closed down to, file for a lost title. So, like I said, she's certified crazy. So,
Mr. Reed?
So if I may, Your Honor, I think I may have a proposed solution or some suggestion to the court about how this might proceed based on the information that Mr. Johnson has provided to the court. So it does sound like an awful lot like we have at least 3 interested parties, and I'm going to guess there's actually a 4th interested party that needs to be resolved here. Going backwards, Mr. Johnson said that he purchased the vehicle from Kevin Burton, who's not a named party, but that would need to be served. Even as a decedent, as Your Honor has noted, he might have an estate, or he might have creditors, or might have family that would make some sort of claim. So service over him, or including him into the case and getting service, is relevant to address his interest. Second, Hillary Bailey is not a named defendant, but she also apparently has an interest because she allegedly purchased the vehicle from Z Auto and failed to title it in her own name. Plaintiff might know where she is for personal service, but if personal service can't be accomplished, she might be swept into the overall service on service by publication, which is likely what's going to be necessary for Mr. Burton since he is allegedly deceased. Third, we have Z Auto, which is apparently the dealer that handled this vehicle, that sold the vehicle to Ms. Bailey. And if I caught Mr. Johnson correctly, what he last stated is that Z Auto may now be out of business. If they are, then service on them, if they have a registered agent, which I didn't have success finding them on the Secretary of State, but if they don't have a registered agent or if they're out of business, service by publication would likely be relevant to resolve them as well. And then finally, based on the way that the chain of title has gone back on this and what I've discovered on it, this vehicle last had a title in Texas I just had it a moment ago. Last had a title in Texas in, I just lost the document. There's Carfax. Last had a title in Texas in 2019. And that, since this passed through a dealership, it's highly likely that person is the last title owner of record, and that person may also need to be discovered and served, or in the alternative, if the court would allow blanket service over any unknown claimants, that may resolve that interest as well.
All right. Mr. Johnson, you can try to do this yourself, or you can try to enlist an attorney who will be able to assist you with publication service. But it seems to the court that the court should follow Mr. Reed's direction here.
Mhm.
And you would have to do a notice of publication
Okay.
In a newspaper. And where was the transaction here? Where did you buy from Mr.
Burton.
Where did it take place?
I sent him money through my Cash App. He had sold me the car because he had wrecked it and it needed work, and he had gotten out of jail previously. So Wichita is where he was living when I got the car. So
Okay, Mr. Reed. Scott, you're muted.
Apology, Your Honor. Just trying to keep it quiet on my end. Just suggestion that as far as like the relevant place to publish, KSA 60-307D has that this would be published in the county where the case was filed. So this would be a Butler County publication. Okay. And also, I'd offer, Your Honor, as I offered to all pro se litigants, I'm a helpful attorney for the department, but I can't help because I can't give legal advice. But I do have a non-advisory informational write-up about publication service that has some examples that if Mr. Johnson needs that, I can provide that to him so that he has some guidance about how publication works, what the statute looks like, and what publications have looked like for past matters that have been successful publications.
Thank you. I appreciate that.
Okay. The court will require publication in this case 3 times in a newspaper in Butler County.
Okay.
But Mr. Johnson, the court will require that in the caption, you're going to need to, or in the body of the publication, you're going to have to name Hillary Bailey,
Mhm.
the estate of Kevin Burton,
Okay.
and Z Auto,
Okay. Yes, Your Honor.
as well as a statement of any unknown claimants.
Okay.
Okay.
Yes,
So
Your
all
Honor.
those people need to be named in the publication notice that you publish in the newspaper.
They do something similar for when you need to file a divorce and the other person is MIA and not reachable and not willing to sign documents and things like that. They make you publish 3 times in the local paper that you want a divorce and you're filing. And if they don't respond within those 3 times, then the court will allow you to go ahead with it.
Yes, Your Honor.
All right. Then I'm going to reset this a couple of months out. It's going to take a couple of months to run the publication and get your
Okay.
return back. You will need to file the affidavit of publication. The newspaper that you publish it in will do an affidavit that they published.
Yes, Your Honor.
It's part of the service that they provide, which you need to insist that they provide to you. And then
Okay.
that affidavit needs to be filed in the case, Mr. Johnson.
Yes, Your Honor.
That proves to the court that the publication did indeed take place. And then I'm going to reset this case for early March.
March.
I can do Monday, March the 3rd.
March 3rd.
Yes. Mr. Reed, would you be available at 2 o'clock that day?
There you go. I
Judge, we
wasn't-
have,
Oh,
Okay.
I'm sorry, we have something scheduled at 2.
What about 3?
3 is open.
Mr. Reed, 3 o'clock on that date?
I'm available at 3 o'clock on March 3rd. Yes, Your Honor.
Okay, that should be very easy to remember, Mr. Johnson.
Yes, Your Honor.
3 at 3.
Yes, Your Honor.
Okay.
Yes.
And we'll review the status of this quiet title action at that time. You should have that affidavit of publication already in the file by that time. When it hits the file, Mr. Reed will have access to it, as will the court.
Okay.
Make sure it's filed in the case with the clerk of the district court. Monday, March 3 at 3. Mr. Johnson, do you need any clarification from the court regarding the parties that need to be named in this notice?
Yes, Your Honor. That would be helpful, I'm sure.
Okay, Mr. Reed, you've got your hand up. I want to address you first.
Sorry, Your Honor. Just want to verify, Mr. Johnson, is your email address pop3luke@yahoo.com?
Yes, it is.
I'll use that to send that to you. And then, Your Honor, I had noted the what you asked for, that you wanted the caption to include Hillary Bailey, estate of Kevin Burton, Z Auto, and any other unknown claimants. And I'll include that in the message to Mr. Johnson as well.
Okay, thank you. Thank you. I
you.
appreciate that. That will assist him.
Thank you very
Very
much.
well. As always, I appreciate your cooperation of you and your department, Mr. Reed.
Certainly, Your Honor.
All right,
Yes.
anything else at this time, Mr. Johnson?
No, Your Honor. Thank you very much. I
I'll
appreciate it.
see you by Zoom Monday, March 3 at 3.
Yes, Your Honor. I'll see you then.
Very well. We'll look at the case again at that time. If there's nothing further, this matter will currently be in recess, and this meeting may be ended for all at this time.
Thank you, Your Honor.
Thank you, Scott.
All right, is Nathan Smith, what are we doing on, is he here?
Right here, sir. Right here.
Okay. Chris, is that yours?
It is, and I'm glad he showed up. The phone number I had didn't work. So Nathan, we're going to need to take care of that after court.
Do you need to visit with him?
Yeah, probably better, Judge.
Okay, and then, is Matt Stewart, is he the one there at the Elk County?
He is, and we're ready for sentencing on that.
Okay, well, if you want to visit with Mr. Smith, I've got a couple other sentencings we can take up while we're waiting.
Okay, thanks.
All right, we can take up either Eubanks or Pullery's. Let's take up Eubanks first, and that's him at the jail.
That's correct, Your Honor.
Sorry, guys, I missed this long space. Mr. Eubanks is in the stripes, I think.
All right, we'll go on the record in State of Kansas versus Kanaya Eubanks, case number 23 CR 171. Would counsel announce appearances, please?
May it please the court, the state appears by Jill Gillette, County Attorney.
Nia Eubanks appears via Zoom from the Greenwood County Jail, and with counsel Eric Hartenstein appearing via Zoom from the Sedgwick County Courthouse.
All right, Mr. Eubanks entered a plea of guilty to unlawful possession of controlled substance back on July 25th. Sentencing was originally scheduled for October 9th. Mr. Eubanks failed to appear. Case was set over. Well, eventually he was picked up on a bench warrant, then sentencing was set for today. I've received a PSI indicating a criminal history score of I. Ms. Gillette, any objection to the criminal history score?
No, not from the state.
All right, and Mr. Hartenstein?
No objection.
Okay, it doesn't look like he has any prior criminal history. So I'm assuming, Mr. Eubanks, you don't object to the criminal history score of I?
Yeah, I don't object.
All right, I will establish criminal history score of I. Ms. Gillette, are you aware of any legal reason why we should not proceed to sentencing today?
I am not.
And Mr. Hartenstein?
No, nothing known to the defense.
All right, this is a presumptive probation case. I'll take recommendations from the state at this time.
Your Honor, this is a possession of methamphetamine case. He has scored out for probation. He is out of state, or he would have been screened for Senate Bill 123, but his primary residence is not in Kansas.
Jill, I don't think that's correct. There is a 123 screening with the PSI, and he lives in Wichita.
Oh, okay. I thought he was in a vehicle with a bunch of individuals from Colorado.
Well, he was certainly passing through the county.
Yeah. So he has scored out. He is scored for probation of 12 months. He has post-release supervision of 12 months. We're recommending the underlying standard 11 months, up to 20% good time credit. He does have 50 days of jail credit up to today. That is set out on the face sheet of the PSI. He does have a KBI lab fee of $400, DNA database fee, court cost. He does have correctional supervision fee of $120. Booking and fingerprint fee is $45. And he was assessed for Senate Bill 123, but there's not an offender reimbursement because he was not granted Senate Bill for his low score. We asked the court to inquire pursuant to Robinson as to bids and application and attorney's fees. And he was appointed Mr. Hartenstein. At first, he did not qualify for a court-appointed attorney, but I believe he ended up losing a job in there and then ended up qualifying later. There's no other cases that are currently pending to run this concurrent or consecutive to.
Thank you, Ms. Gillette. Mr. Hartenstein, your recommendations?
Thank you, Your Honor. Mr. Eubanks has been in custody for, he says 50 days now. The PSI shows 48 on his current incarceration, so we aren't going to object to that. Mr. Eubanks lives in Wichita. He is unemployed. The rather lengthy report indicates that we're okay with the recommendations, the presumption of probation, standard conditions of probation, standard fees and costs. I would ask that you make the Robinson findings that repayment of any of these attorney fees would create a burden for Mr. Eubanks in excess of his ability to pay based upon the court costs involved, the lab fees involved, the treatment costs that I believe are going to come about here, and the time it's going to take him to participate in that treatment. So I think that at the very least, a reduction in the attorney fees, and if Your Honor finds fit, a complete waiver of additional attorney fees above the $100 application fee. Like I said, he lives in Wichita. We'd ask that supervision be allowed to occur here in Wichita with probation here in Sedgwick County.
Thank you, Mr. Hartenstein. Mr. Eubanks, is there anything that you would like to say before the court pronounces sentence?
No, Your Honor.
All right, Mr. Eubanks, for the primary offense of unlawful possession of a controlled substance, a level 5 non-person drug felony with your criminal history score of I do sentence you to the standard term of 11 months with the Secretary of Corrections. You are eligible for 20% good time credit and are subject to 12 months post-release supervision. This is a presumptive probation case. I'm going to place you on probation with court services for a period of 12 months. I will give you 50 days of jail credit for time that you've already served on your case. You will need to follow all standard conditions of probation, including refraining from the use of alcohol or illegal drugs. You are subject to random breath, blood, and urinalysis testing. I have received as part of the PSI an evaluation that recommends level 1 outpatient treatment. I will order that you complete the recommended treatment program and follow all recommendations. You need to notify your probation officer of any changes of employment, residence, or phone number. You're not to violate the law. You have contact with law enforcement. You need to let your probation officer know within 24 hours. You need to follow all curfew and travel restrictions that are part of the probation program. Tell me a little bit about your employment situation.
I was working prior at McDonald's, but I don't have a job right now, but I know that I do have jobs lined up, so I can get it within less than a week.
Okay, what type of work will you be doing?
I usually do fast food. I usually do upper management. I've had nothing but upper management, so.
And you live in Wichita?
Yes, sir. Yes, Your Honor.
Okay, you need to gain employment as a condition of probation.
Okay.
Now, tell me about your educational history. You don't have a GED or a high school diploma?
No, I do not. 11th grade is the highest I went.
Any reason why you can't get a GED?
No, I am planning on getting that in the future anyway.
Well, clearly he doesn't need one since he only works upper management. I mean, we've got a meth addicted high school dropout who clearly has everything worked out because, he only works upper management and he's got several jobs lined up. I don't know that I believe all that.
Okay, that would greatly, well, I say greatly, but that would increase the type of work you could probably get if you had a diploma or a GED. I'm going to order it as a condition of probation that you complete a GED or a high school equivalency exam.
Okay. I was planning on doing that. I was actually working on that prior to getting in custody.
Hopefully you're a step ahead there and you can just get in and knock that out. I think it'd be good for you.
Yes.
I'm gonna order you pay the court costs in the case. Ms. Gillette, did you mention a KBI lab fee?
Yes, there's a KBI lab fee, court cost, DNA database fee, correctional supervision fee. There should be a booking and fingerprint fee and a Senate Bill 175 assessment fee. And then whether or not you say anything on attorney's fees.
All right, so you're gonna be ordered to pay the court costs of the case. I'm not going to assess a fine, however, I'm gonna order that you pay $400 to reimburse the KBI for the testing they did on the
Okay.
drugs in this case. Since this is your first felony offense in Kansas, you will be ordered to submit a sample of DNA and pay the database fee of $200.
We already do the DNA.
I am gonna order that you pay the probation supervision fees, as well as a booking fee of $45. Do you have any other holds on you, Mr. Eubanks?
I do not believe so, Your Honor.
Okay. I'm gonna order that you pay the bids application fee. However, since you've been in jail now for a period of time and are unemployed, all pursuant to State versus Robinson, I'll waive reimbursement of bids court-appointed attorney's fees. I'm gonna order you pay a minimum of $50 a month towards your costs and fees. And if I
Okay.
didn't order the Senate bill assessment fee of $175, I am ordering that you pay that. I'm gonna give you a little bit of a cushion. Your first $50 payment is due by the last business day of February of this year. And you need
Okay.
to pay at least 50 by the last business day of each month after that, until you get everything paid in full. You're gonna need to pay more than that along the way, but that'll give you time to get out, get a couple paychecks before you have to make your first payment.
Okay, thank you.
You may have a right to expunge this conviction off of your record at some point in the future. If you're interested in expungement, I would suggest contacting an attorney or doing some of your own research to figure out when you might be eligible to do that, if this is an expungible offense, and so forth. You do have a right to appeal this sentence. If you choose to appeal, you have 14 days from today's date. If you can't afford an attorney to do an appeal, one would be appointed for you. As a convicted felon, you're not to be in possession of firearms, and there are the loss of certain civil rights, such as the right to vote, until your sentence has been fully discharged. Ms. Gillette, can you think of anything that I've failed to address?
Judge, did you advise about prohibition of firearms and civil rights?
I did.
That's it. That's all I got.
Mr. Hartenstein?
Nothing further, Your Honor.
All right, Mr. Eubanks, why did you fail to appear last time?
I was going through some mental struggles along the way. I had currently I just I was just going I was in my head. After this, I plan on seeing a doctor for like mental headspace, I guess.
Do you need to have a mental health assessment?
Probably. I was gonna go whenever I got to Wichita and see my KU doctor to get me a doctor to take to to get me a mental, see if because I have I forgot what it's called, but like for schizophrenia down my family tree. So
Okay. You're not Senate Bill 123 eligible, so you're gonna have to pay for your drug and alcohol treatment yourself. I'm not gonna order that you do a mental health assessment because I don't want to burden you with a bunch of more fees on top of this, but
okay.
if you feel you need that and that's going to make you successful on probation, you need to do that. Perhaps
Yeah,
who do your drug and alcohol treatment have somebody who can give you some mental health treatment, because you've been sitting in jail for another 48 days that you never would have had to do had you just showed up to court. If
yep,
you mess up on probation now and don't show up to probation, you're looking at doing 11 months in prison.
yep,
So you need to be successful on this probation. You need to report as directed. You need to stay clean. You
yes,
need to make your payments. Otherwise, you're gonna sit in jail or prison. So,
thank you.
all right, Miss McManus, you need to set up a breakout room to visit with him? Does he just need to call in?
Your Honor, could he call the Butler County office, please?
Okay, do you have something to write with?
Yes, I have,
Okay,
Yeah,
could you
personally.
provide that phone number, Miss McManus?
Yes, that would be 316.
All right, call that number. I'm assuming you'll be released today. Are you gonna have somebody that can come pick you up?
I've already made arrangements a little prior to this. I have my mother coming
Okay,
if
I
I were to get out today.
you need to call this court services number today when you get released from jail.
Okay,
I'm
and
assuming,
that's the number that you just gave me, right? Okay,
correct.
awesome.
And that's the number for court services. That's the probation agency that's going to be supervising you. So make sure you call and do what they have to say. Do what they say.
Yeah. And so all of my stuff is getting moved over to Wichita, correct?
Well, I'll allow it to transfer to Sedgwick County, but you need to
Okay.
report to Butler County until they've authorized you to report to Sedgwick County, because Sedgwick County has to agree to supervise you. So
Okay.
You'll report to Butler County until they tell you you can report somewhere else.
All right, thank you.
All right, counsel, anything else?
I can't think of it.
No, Your Honor.
We'll be in recess. Good luck to you, Mr. Eubanks.
Thank you.
You're Kathy Stewart, is that correct?
That's correct.
Okay, thank you. You were with us last time.
I think so, yes.
All right, you guys. This one's fun. Ready to see a guy sue Kansas for $4 million and have a chance at it?
Right, is somebody there from the correctional facility with Mr. Simmons present?
Turn this up some. Turn it up.
Hold on a second. I'm getting there.
Okay. Okay.
Oh, you're on there.
I was on now. Okay. All right.
Good afternoon, Mr. Simmons.
Good afternoon, Judge.
Do you need any time to confer with Miss Stewart, who is our interpreter, before we get started?
No, sir. I'm ready.
All right. All right, we'll go on the record. This is in the District Court of Butler County, Kansas. Case is entitled Mr. Willie Simmons versus the Kansas Department of Public Health, Warden Sam Klein, Vincent Weary, Miss Johnson, Tamika Koya, inmate Marvis Moya, and Ryan Stork. It is case number 21 CV 110. The plaintiff, Willie Simmons, appears in person by Zoom. Also appearing is Kathy Stewart, who is a sign language interpreter, who is interpreting for Mr. Simmons. We are before the court today on motions filed by Mr. Simmons for default judgment in regards to inmate Moya and to the Kansas Department of Health. Mr. Simmons, are you ready to proceed on these motions?
Yes, Your Honor.
All right, Mr. Simmons, I'll allow you to make argument in support of your motions at this time.
Yes, Your Honor. So you want me to read the motions to you, Your Honor?
You don't need to read them verbatim. That this is your opportunity to explain to the court why you feel you're owed relief according to the motions that you filed.
Well, Your Honor, the motions that I filed for my default relief was due to the deliberate indifference and the negligence of the health department, where they failed to protect me from the coronavirus, and I sustained injuries, you know, to chronic lung disease, to my asthma and emotional distress, and I was in the hospital, and I'm on 5 different asthma inhalers, and I have a weak immune system, and I brought evidence where medical. These are asthma inhalers for my lung from the coronavirus right here. I have another one right there that's to control my lungs. I'm on the Lofin medication for my lungs. So to control my lungs, my immune system is weakened. It caused my spine to become weakened, and I pass bowel movement on myself. I can't hold my urine. I wear pull-ups and stuff. So I mean, this coronavirus was a body injury to me, and this is why I filed my default judgment on the damages on them. And the other issue was that in my amended complaint, where I stated my issue for my relief, and I stated all of the protocols that they failed to follow their protocols in protecting the inmates and me. You know, when they allowed staff to come in with coronavirus, and we all got infected. I would never got infected, you know, if they would have followed protocols, and they never gave us any sanitation, you know, equipment to clean. They sent me to Lansing correctional facility at the time, and when we got there, they put us in the same contaminated environment, and then put us on a contaminated bus, and I got even sicker. And then they brought me back, put me back into another cell with the coronavirus with several other inmates. And I got sick even worse, so then had to go to the hospital. And ever since then, I have a body injury where, you know, I have to take all these asthma inhalers for my lung and for my breathing problems. So, I mean, this is why I filed this lawsuit for my damages. And the other issues is what you probably read in my my complaint when I filed my federal rule of civil procedure 55B and 1, asking for this hearing on my default judgment.
Okay.
And,
well, since you're requesting a default judgment, we need to procedurally look at a couple of things. You asked this court for leave to file amended complaint, which this court granted back in July of 2023.
yes.
You filed that amended complaint on July 28th, 2023, and requested service on the Kansas Department of Health, correct?
Would you help me repeat that last statement?
Okay. Did you request service, or that the Kansas Department of Public Health be served with a copy of the amended complaint?
Yes, Your Honor.
All right, and I'm looking at return of service of summons filed with this court on July 28th, 2023. Attached to that is a certified return receipt. I believe that is dated September 13th, 2023. Is that the summons in which you're relying upon, Mr. Simmons?
Yes, Your Honor.
And according to the court file, the Kansas Department of Public Health has never filed an answer. Have you ever received an answer from the Kansas Department of Public Health?
No, Your Honor, because they never sent an answer, a response to me, because if they did, my unit team, they have a form that they fill out from the mailroom. When all legal mail come in, they address it. And then this unit team, Judy, she brings it down, and then she put her signature on it. She signs it as legal mail coming inside, any mail come in. And then I have to sign it, and she open it, she's copy it, and she give it to me, and then they log it all in. So I never seen a response to them at all. Excuse me.
All right, and what relief are you requesting as part of your judgment?
Well, Your Honor, I was my relief. I had a relief of $100,000 in my amended motion that was filed on April the 25th, 2023, for the $100 and the $20,000 from each of the defendants. But in my default judgment, I put $4 million of a judgment, and I don't know if it's excessive, but I mean, I couldn't put a price on my health at the time, so I put the default judgment for the for the $4 million. So I will let you determine if the amount is excessive, or to grant me the $120,000 in my amended complaint for their default judgment on April the 25th, 2023.
Give me just a second. When was this? Are you referring to the amended complaint filed in July of 2023?
Yes, Your Honor, I have a copy of it right here.
So you're asking judgment be granted against the Kansas Department of Public Health for $4 million?
Yes, Your Honor.
Okay, I'm looking through the amended complaint, and I don't see that amount.
Well, in the amended complaint, Your Honor, I had $100,000 joint service from the defendants, and then $20,000 for the actual damages. On the motion for I filed to amend upon the ruling 15A of Federal Rule of Civil Procedure, when I request a lien to file an amended motion against the parties, and the last page of it, page 4.
Well, Mr. Simmons, we're not in federal court. We're in state court.
Yes, sir.
Now, the only people who have been served as part of this lawsuit are inmate Moya and the Kansas Department of Public Health. So the only judgment that can be obtained would be against those two defendants.
This is a risky one. This is a slippery slope kind of case, because if he is granted judgment, then couldn't every inmate sue, and then this case would be precedent? And Kansas didn't take it seriously. They didn't show up. They didn't respond. So he'd be granted default judgment. This is a big Kansas oopsie.
I understand, Your Honor. So
Give me just 1 second. First of all, regarding the Kansas Department of Public Health, I do find under KSA 60-303 that they were properly served with process and have not filed any sort of an answer or appeared or availed themselves of the court.
And Your Honor, I have sent them other letters asking them why they haven't responded, and they still haven't responded back. And I asked them to send me copies if they was going to respond, and they never did. And this case been going on for 3 years and almost 11 months.
Now, the amount that you're requesting as judgment against the Kansas Department of Public Health, I do have a little bit of an issue with based upon what I have before me at this time, which is essentially your amended complaint and the request you've made here today for the $4 million. Now, it's clear that the Kansas Department of Health is in default. Now, what I'm looking now at KSA 60-255, which is the Kansas statute for default judgment. In subsection C states a default judgment may be entered against the state, its officers, or its agencies only if the claimant establishes a claim or right to relief by evidence that satisfies the court. So that's a little more stringent than just taking a default judgment against a non-state agency. There has to be a showing by evidence of why you're entitled to that amount of relief.
Thank you. I understand, Your Honor. So I will let you make the determination of the judgment to reduce that balance.
What evidence are you, how did you come up with that amount?
Well, he's clearly willing to negotiate somewhere between the $100,000 amended complaint and the $4 million original complaint, Your Honor.
Well, from my complaint that I filed to you, and my amended complaint of them violating protocols and not following their procedures, and me having a body injury, and me being in the medical facility and hospital suffering.
Okay, now that covers the causation of why the court should grant judgment, but the amount that you're requesting, what are you relying upon for that amount?
Well, 300,000 is not excessive. I mean, for my damages and my suffering.
Well, that's what I'm unclear of as to what your damages are. What are your damages?
Are you referring to like my puberty damages and actual damages?
Correct. Why are you entitled to the amount that you're requesting?
For my pain and suffering.
Okay. The issue I have is you've stated that, and I'm not doubting that you've had pain and suffering, but in order for the court to assess that type of a judgment, I'm going to need some evidence other than your statement.
Well, I put the evidence, Your Honor, in my amended motion. So I'm assuming that you've read my amended motion.
I've read the amended complaint, if that's what you're referring to, filed on July 28th, 2023.
Yes, sir.
Do you have any medical records or anything like that to verify these medical issues that you've experienced?
Yeah, you have to prove that these weren't pre-existing conditions in any capacity.
The medical staff have the medical records. They won't allow us to have them because they say that it's a safety and security risk to the institution for us to have our medical records. And the second issue was I had in my complaint when the health department took responsibility, joint responsibility to the fact that, well, that they took 72 hours, they told us to leave our property in the sale for 72 hours. And when they sent us to Lansing, and I had to leave my property in the sale for almost 13 to 14 days. And with another offender, which the correction officers now refused to let us take or pack our property. So they said that we was going to go back to that sale, which we never went back to that sale. And I lost all my brick art stuff. I lost a $4,000 hearing aid, which I had that in there. I lost all my property. I lost all my legal matters, all the legal stuff that I had, my transcripts and everything. I couldn't fight my case. So I listed all that stuff in there for damages and costs. So that of my lost property, holding the health department because they took joint responsibility in the matter of them sending us to Lansing, and I lost all my property and stuff. And then I end up, getting the coronavirus and those issues. Jan, I'm not an expert and an attorney, so I leave it in your hands to make the judgment of liability because, I mean, my medical records will show, and I have all these asthma inhalers, and I'm on Valonga medication, lung medication and stuff, and I have all kind of medical issues right now from the coronavirus, and my immune system is so weak. I'm taking medication for that. So, I mean, I barely move around. I'm falling off of balance. I've never been the same since I had the coronavirus. So, I mean, I've been having a difficult time, and it's been a bodily injury from them not protecting me from the coronavirus, because, I mean, if they was following protocols, their staff was, medical staff, and because the Horizon stated that the health department told them some of the things, what to do and what they couldn't do, and not to give us certain things to protect ourselves with because, the state didn't have it. So that makes them liable for them failure to protect us, from any type of bodily harm or bodily injury or any type of disease coming into the institution. Because they could have prevented this, but they didn't, but they transferred us back and forwards, and we got contaminated, and got even sicker. And me, myself, I have.
What I'm going to need to do here, Mr. Simmons, is have you prepare for the court an itemized list of the damages that you're seeking from the Department of Health, and not from any of the other named defendants, only the Department of Public Health, an itemized list as to what you're seeking and why you feel you're entitled to that. I feel it's necessary under the KSA 60-255 that I have a little bit more in front of me before I can make the determination of damages as it relates to the Kansas Department of Public Health. So I'm going, as it relates to them, I'm going to ask that you submit that to the court, the itemized list that I've just gone over, as well as any additional evidence you may have that supports your request for relief.
Yes, Your Honor. So do I have a certain amount of time to do this?
I'm going to, in just a minute, I'm going to set a new court date for us, and then I'm going to set a deadline for you to submit that to the court. But before we do that, I want to address your request regarding inmate Marquise Moya.
Your Honor, Marquise Moya was served because he was a prison. He was my cellie, and he was when the sheriff came in. I watched him serve him, and then the default judgment, I served him because he was here. on his compound out on the yard. So I served him with a copy of the default judgment and with a notice of the default judgment. And he refused to, he stated to me that I was a inmate, a prisoner, that he didn't have to respond to a complaint, you know, that I filed against him. So I told him he had to make a respond back to the courts. So he decided that he wasn't going to respond back, and his being arrogant, stating that, you know, he don't have a right to respond back to the courts or to me on a lawsuit against him. On what happened was, Your Honor, he was my cellie at the time, and when the health department took joint responsibility, they told the KDOC to have the inmates, you know, to stay in the cell, and the property had to stay in there for 72 hours. So my property stayed in the cell with him for 72 hours while I was at Lansing, but I was there about maybe 13, 14 days, and then they brought us back. So when I went to receive my property, thought I was going back to that cell that they stated that I was supposed to go back to, which all my property was missing and gone. So, and I had them file Form 9s. They seen him on videotape, which you have copies of my Form 9s from staff stating during the investigation. They found some of my property in his possession, but when I went to ask them about that property, they stated that the property got lost during the investigation, and it never was returned to me, half of the property. So, and the other property that he had stole, he sold in the process, and they seen him on camera, him and James distributing, selling my property to other inmates in the institution. So, and this is why I filed a judgment against him.
And what amount of relief are you requesting against inmate Moya?
Based in general, Your Honor, the $20,000 for my in the process of my hearing aid, all my art matters, the stuff that I had. I'm an artist, Your Honor. So, and my legal matters, all my property that I had in the cell, my clothing, my new clothing and stuff, my sweats, my TV, the radio, all the property and stuff that was in the cell that he distributed and sold for his habit of drugs that he did. So, and I never got.
You're claiming that you had $20,000 worth of property in your cell?
Well, I'm adding on to my pain and suffering and my the damages, you know, that I suffer. So, I mean, it might be seen a little excessive, but I mean, he didn't think about that time when he decided that he took all my property and they sold all my property. So, I mean, me myself, I know it's wrong, Your Honor, but to set an example for the rest of the inmates, because they figured that, you know, that they can't be sued. So, and I thought I'd just make an example out of him due to the fact that, well, that he stole all my property, and he's on videotape, Your Honor, and staff made a report, and half of the property is in the possession, and they never returned a majority of my property. So, I mean, and I just filed a $20,000 default judgment against him on my losing all of my property. And it got stuck.
Also request that you prepare an itemized list of what you're seeking from inmate Moya as part of this judgment.
Right.
Yes, Your Honor.
And then I'm going to set a court date about 45 days out. Does that give you enough time to prepare this paperwork and get it submitted to the court?
Yes, Your Honor.
Okay. Angela, if you could set a date about at least 45 days out, please. Give us about an hour of time.
Judge, I have February 12th at 3 o'clock.
February 12th at 3 o'clock. Is that a time that would work with the correctional facility? Are you still going to be you're at Hutcherson?
Yes, Your Honor.
Will you still be there on February the 12th?
Yes, Your Honor.
Judge, we should probably do it over there. February 14th at 10 o'clock.
February 14th at 10 o'clock rather than February 12th.
Yeah, just to say.
All right. Any reason to believe that February the 14th at 10 o'clock won't work for you or for the correctional facility, Mr. Simmons?
It'll work for me, Your Honor. Your Honor, let me specify if I can be correct in what you're saying. So what you're requesting is that I put down my damages for what compensatory damages, actual damages, and the damages that I'm actually asking for in my default.
Correct.
That's what you
I need you to break down, if you're requesting $4 million, I need you to break that down as to what the amount entails. If part of it's for pain and suffering, you need to set that down. And then anything else, just break it down, the amounts that you're requesting.
So add up to the 4 million.
Correct.
Oh, I understand.
And do that for both inmate Moya and the Department of Public Health. And then submit any additional evidence that you have, not necessarily statements, but if you have any medical records, paperwork, anything that gives a basis for your request for relief, you can submit that if you have it.
Yes, Your Honor.
And then I'm going to set a deadline for that to be submitted to the court.
Judge Crum is taking this ultra seriously. I don't think he's going to get $4 million, but I think he's going to get something, especially out of that default judgment. It's going to be up to the courts to decide, what's a fair compensatory amount, but they didn't show. They didn't respond. They didn't take this seriously. Whether or not he is owed those damages, whether or not his conditions were pre-existing or all of his breathing troubles came from getting the virus or not, or whether there was, poor handling of the situation, it doesn't matter. A default's a default. He's going to get something.
I'm going to request that you have that sent to me or the care of the court by February the 5th. Then that will give me sufficient time to review that before the hearing on the 14th.
Your Honor, is it possible that you sent me a court order with this issue, with these dates and stuff on there? This way I won't forget, because I do have a short time memory and I write stuff down. I have to keep going back over it and reading it to let it sink in. So if I can know when that time comes that I have something to bring to their attention too, that this date is coming up on a court order.
Well, Angela, do we provide any sort of we provide a hearing notice to the correctional facility, correct?
Yes, I'll file an order for hearing and send it to them with the Zoom link.
And then can we put this February 5th deadline for submission of the paperwork on there as well?
Yes, I can.
Okay, so Mr. Simmons, it sounds like an order for hearing will be filed and it'll include those dates.
I appreciate it, Your Honor.
Do you have any additional questions, Mr. Simmons?
No, Your Honor, I just want to get this caseload over with so I can focus more on my criminal case. And because this is been a burden trying to keep this case going on.
I understand, you and me both, Mr. Simmons, but hopefully we can get it concluded when we come back on the 14th of February.
Yes, Your Honor, I appreciate it, and I thank you a lot.
All right, thank you. Ms. Stewart, thank you very much.
Thank you.
For your services here today. And if there's nothing further, we'll be in recess.
All right.
Have a good day.
I'm definitely going to try to catch the update.
Thank you there for having him at the correctional facility for us.
You're welcome.
I definitely don't have a date for that day. So, you know, no plans. It'll be easy to dedicate my time to that. That'll be my date. Date with Judge Crum. Oh, shoot.
This is in the District Court of Butler County, Kansas, case entitled State of Kansas versus Elizabeth Louise Albright, case number 2024 CR 76. Ms. Albright appears from the detention center's Zoom location. Brett Sweeney appears for the state of Kansas. James Watts as defense counsel. This matter comes before the court at this time for sentencing. The court's docket notes indicate that this matter came before the court last on October the 29th of 2024. At that time, the defendant pled guilty to possession of methamphetamine, a level 5 drug felony. Court set sentencing for today after ordering a pre-sentence investigation and report, which has now been received as compiled by Carrie Seeley, pre-sentence investigator, who is present on this meeting. I trust we're ready to proceed to sentencing from the state's perspective. Mr. Sweeney?
I think so, Your Honor.
From the defense side, Mr. Watts?
Your Honor, as I know, I just got back in the country from a vacation, and I had believed that I had prepped everything before I left. This is clearly going to need a motion to depart as she 3 strikes on this matter. And as I said, I thought I had prepared all those motions before I left, but I apparently missed this one. Judge, I'd ask for a short continuance to assemble that motion. It will not take very long. I should have it filed today or tomorrow.
All right. What's the state's position on the request, Mr. Sweeney?
No objection, Your Honor.
Court is inclined to grant the request by the defense. Mr. Watts, I know that you're generally tied up on Monday afternoons with the criminal docket judge, which is not this court, on Monday, January 6th. But I also know that you generally don't have conflicts on the misdemeanor docket. So I'm going to suggest 9:00 a.m. on Monday, January 6th.
I have in front of Judge Hart at 9:30, but I can take it up at 9.
Very well. Court will reset the sentencing in the Albright case for Monday, January 6th, 9:00 a.m. Defendant obviously must be present on the Zoom meeting at that time. January 6th, 9:00 a.m. for further proceedings in the case. I want to make sure that the state has had an opportunity to review the report prior to court. Mr. Watts, if I were to establish a deadline at noon on Friday, January 3, is there any reason you believe you can't make that?
No, Your Honor.
Very well. Then I'll ask you to provide that. And also, if you'd send a courtesy copy by email to the court by that same time, Friday, January 3rd at noon, with the sentencing reset to 9:00 a.m. on Monday, January 6th by Zoom.
Yes,
We'll
sir.
probably use the same Zoom numbers as we did today.
Yes, sir.
Right. Ms. Albright, you seem to be a bit emotional. Okay, she's muted. I do want to give her an opportunity to address the court. Can we unmute her? Ms. Albright?
Yeah, I've been trying to get my attorney to meet with me before court for multiple times now. I'm not understanding why I'm not being sentenced today.
I think he's making a request to file a departure motion. You're presumptive prison on this case.
I'm presumptive probation.
Actually, you're not.
What? I was never even able to meet with this Carrie Seeley on a PSI. She never showed up. She was a no-show to our meeting here, so I don't understand what's going on.
All right. Well, we're going to continue your sentencing. That will allow more time for whatever conferencing is necessary to Monday, January 6th at 9:00. According to the face sheet of the pre-sentence report, there's a special rule application here. Ms. Albright, you are presumptive prison because this is your third or subsequent felony drug possession conviction.
I've had my record expunged of all those things before, Your Honor. I don't understand.
All right. Further explanation obviously needs to take place between you and your attorney. Mr. Watts, do you want an opportunity to confer with Ms. Albright and right now by Zoom? We can leave the meeting open and put you in a breakout room.
I'm fine with doing that, Your Honor.
Okay.
So you got your drug offenses expunged and then went on to get more drug offenses. Does it really wipe them out? Or do they still get to be used in the enhancement? I guess we'll find out.
I'm going to go ahead and recess the court proceeding at this time, cease recording and broadcasting, but leave the Zoom meeting open for a private breakout session between attorney and client.
All right, guys. Just a little bit of context here. I did have other hearings for this gentleman, but they were on the Ava drive, the drive that got AVA'd. So, and I have not been able to retrieve the data from that drive. So, I have two hearings. They're both sentencings. So this is his first sentencing that I have in May. And then the next hearing that you'll get to see is a more recent one. So I just wanted to give you a little, because it looks kind of funky. There's no context to the first one as far as why I'm, randomly including it, but you'll see why.
This is in the District Court of Butler County, Kansas, case entitled State of Kansas versus King Value Valonga. It's case number 2024 CR 59 with Amber Norris appearing for the state, Joseph Favre's defense counsel, defendant appearing from the Butler County Detention Facility Zoom location. I'll also note the presence of Kit Russell from Court Services, who is the pre-sentence investigator in this case. This matter comes before the court at this time for sentencing. Court's docket notes indicate that the defendant appeared before this court on March the 11th, 2024. At that time, entered a guilty plea to count 1, burglary, a level 7 felony. All other counts were dismissed pursuant to plea agreement. The court ordered a pre-sentence report, set sentencing for today. Court has received a pre-sentence investigation report compiled by Mr. Russell. It does appear that both attorneys would have been supplied a copy of this. Is there any objection to the criminal history which is lodged by the state at this time?
No objection, Your Honor.
Any objection by the defense, Mr. Favre?
And there's not, Judge. I reviewed that with Mr. Viamunga, and there's no objection.
Court will adopt the criminal history as stated in the report and finds that the criminal history score applicable to today's sentencing is criminal history score I, and the court will proceed further accordingly. Ms. Norris, do you know of any legal reason why sentence should not be pronounced in this case at this time?
No, Your Honor.
Mr. Favre, are you aware of any such legal reason?
I'm not, Your Honor, no.
I'll address the defendant personally and ask him, do you know of any legal reason why sentence should not be pronounced in your case today, or any other good reason?
No, Your Honor.
We'll proceed further then. Counsel, I'm not aware that there's been any motion for a departure sentence or any other sentencing related motion of any kind to address. Does the state have any such motions to pursue?
No, Your Honor.
Does the defense, Mr. Favre?
No, Your Honor, I do not.
Are there any victims and members of a victim's family that desires to address the court in relation to this sentencing? The court finds no such persons on the meeting. So at this time, the court will ask for recommendations from counsel regarding an appropriate sentence, starting with Amber Norris on behalf of the state.
Thank you, Your Honor. Regarding count one, we'd ask the court follow the presumption. This is a presumptive probation case. Defendant would be able to earn up to 20% good time credit, would be subject to 12 months post-release if necessary. Ask the court assign him to 12 months in the Department of Corrections, which is the standard mid-box sentence. He has earned, as of today's date, 101 days of jail time credit. Based on the new rules, he actually is eligible for and required to do mandatory drug treatment, and that would be for up to 18 months with community corrections supervision with all standard and PSI recommended probation conditions. The court will need to assess the costs and fees of the action to the defendant. There is no request for restitution in this matter. Court will need to also address court-appointed attorney's fees and the bids application fee, as Mr. Favre is appointed. Assess the $200 DNA database fee and the SB 123 assessment and reimbursement fees that total $300. Otherwise, Your Honor, I don't think I have any further recommendations for the court at this time.
Very well. Mr. Favre, do you have any recommendations for the court regarding an appropriate sentence?
Judge, we join in those recommendations listed by Ms. Norris. Mr. Viamunga, I'll inform the court, has been in custody for a very long time, so he is not employed when he gets out. He does intend on returning to work in Derby, Kansas at the smoke shop he was previously working at, but he is going to be living in Sedgwick County. That job, from what I understand, pays about $12 an hour. It doesn't pay a lot of money. So we will ask the court to consider his financial condition when assessing attorney's fees. Other than that, no other recommendations.
Very well. At this time, the court will address the defendant personally and ask him if he has any statements that he wishes to make in mitigation of punishment or anything further that he would like to present to the court.
I do not, Your Honor.
All right. Court pronounced sentence in the case at this time. Court hereby establishes count one as the base sentence in this case for the offense of non-residential burglary, a severity level 7, non-drug, non-person felony, in which the defendant has a criminal history score of I, thus placing him in grid box 7I. Court hereby sentences the defendant to the standard term of 12 months in the custody of the Secretary of Corrections of the state of Kansas. On this sentence, the defendant may earn up to 20% of good time credit and would be subject to 12 months of post-release supervision. The court finds that this is a presumptive probation matter. Further, the court finds that the combination of a high-risk needs score combined with the outcome of the substance abuse evaluation in this case would indicate that there's a high probability that he has a substance abuse disorder. Therefore, the court will order mandatory Senate Bill 123 treatment in this case. Defendant is required to complete successfully a Senate Bill 123 substance abuse treatment program, including any aftercare recommendations that may be made. This is pursuant to an approved alcohol and drug evaluation. The defendant shall not possess or consume alcohol or illegal drugs while on probation. At his ISO's request and at his own expense, he shall submit to random breath, blood, and urinalysis testing, perform community service work pursuant to program requirements, gain and maintain employment throughout his probationary term, notify his ISO of any changes in employment, residence, telephone number, email address, or contact with law enforcement within 48 hours, have no contact or be on the premises of the victim Bison Liquor Store on Rose Hill Road in Rose Hill, Kansas, submit his DNA to the KBI databank and be responsible for the $200 cost of the test, abide by any curfew or travel restrictions imposed by his officer, follow all standard conditions of community corrections probation, not have in his possession firearms or dangerous weapons, avoid disreputable characters and places, and make monthly payments as determined by the court. This will be an up to 18 months probation supervised by community corrections because of his high risk score on his risk needs assessment. Defendant is ordered to pay a felony DACA fee, felony probation fee, the $200 DNA fee, as referred to earlier, $300 in Senate Bill 123 reimbursement costs. Regarding bids assessments in the case, the court finds that this defendant has had a considerable period of incarceration prior to the sentencing. The court determines that there's some other significant costs in this case that have to be paid. The court will be waiving a bids application fee and bids attorney fees under the facts and circumstances of this matter. Court will require the defendant to pay a minimum amount of $100 a month on these obligations, starting with the calendar month of June of 2024 and every subsequent month until the case is paid in full. Does the defendant have any other holds on him currently?
No, I don't believe so, Your Honor.
Great. Court is going to order him released on community corrections probation at this time. Regarding the issue of jail time credit, it does appear that he has amassed 101 days of jail time credit to be set forth in the sentencing journal entries stemming from today. There does not appear to be a victim request for restitution, correct, Ms. Norris? All right.
That is correct, Your Honor.
Some point in the future, Mr. Valonga, you may have the right to seek expungement of this offense. Certain statutory limitations do apply. If you have any questions about your right to someday seek expungement, you can address those to a lawyer and I'm sure get your questions answered. Under certain limited circumstances, a criminal defendant who's convicted in Kansas has the right to appeal a conviction to an appellate court having jurisdiction. If they are unable to pay the cost of an appeal, the defendant may request the court to appoint a lawyer to represent them on appeal and that they be supplied with a transcript of trial court proceedings. Pursuant to KSA 22-3608C, you, the defendant, have 14 days after this judgment in court to file any notice of appeal with the clerk of the district court of Butler County, Kansas. You do have the right to appeal this sentence. If this court has ruled adversely to you at this hearing, I will remind you that there's prohibitions against a convicted felon possessing a firearm, that there are losses of certain civil rights, such as the right to vote, until your sentence is fully discharged. It is the intention of the court to release this defendant on probation right after this hearing. However, I do have Christy Ashenfelter here from Community Corrections. Christy, what direction would you give or request would you make?
Your Honor, if I could get a breakout room with the defendant after the hearing, and I will give him all the instructions he needs.
All right. I'll instruct the defendants to stay on this Zoom meeting after we recess the recording and court part of this. The ISO from Community Corrections is going to give you some further direction about how to get started on your probation. So you need to follow her directions regarding reporting, okay?
Okay.
All right. I want to go over costs again. I know that there's a $200 DNA, $300 Senate Bill 123 reimbursement, felony docket fee, felony probation fee, community corrections fee, all assessed with all bids amounts waived. Ms. Norris, were you seeking any other assessments other than what the court has specifically mentioned and gone over?
I don't believe so, Your Honor. Thank you.
All right. Mr. Favre, is there anything further from your perspective that needs to be addressed here?
No, Your Honor, thank you.
Okay. I'll ask the defendant. Sir, do you have any questions about the court sentencing orders?
I do not, Your Honor.
Okay. This is a rehabilitative probation. That's what it's all about. And the Senate Bill 123 is the most important component of it. Obviously, you need to meet all your conditions, but don't
Right.
forget that this treatment program is mandatory. The alternative is you do your time. So good luck with it. I hope you're successful with it. You become rehabilitated and you don't have to appear before a judge again on a felony case.
Thank you, Your Honor.
Good luck in that regard.
Thank you.
If there's nothing further, we'll go ahead and recess the court proceedings. Let's leave them.
Here we are, 7 months difference. And he's back.
This is in the District Court of Butler County, Kansas, case entitled State of Kansas versus King Solomon Valonga, case number 2024 CR 488. Defendant appears from the Butler County Jail Zoom location. Joseph Favre's defense counsel. Brett Sweeney appears on behalf of the state of Kansas. This matter comes before the court at this time for sentencing. Docket notes indicate that this defendant appeared before this court on November the 1st of 2024. At that time, he pled guilty to an amended count 1, attempted burglary of a dwelling. All other counts were dismissed pursuant to plea agreement. A pre-sentence report was ordered. Sentencing set for today. Court has received a pre-sentence investigation report compiled by Sharon Teal, pre-sentence investigator, who is present on the meeting with us. I trust each attorney has received a copy of this report, and I'll ask the state's attorney first. Is there any objection to the criminal history which is stated in this report?
No objection, Your Honor.
Any objection by the defense, Mr. Favre?
Judge, I've reviewed that with Mr. Valonga, and there's no objection.
Court will adopt the criminal history as stated in the report and finds that the criminal history score applicable to today's sentencing is criminal history score G, and the court will proceed further accordingly. Mr. Sweeney, are you aware of any legal reason why sentence shouldn't be pronounced in this case here this morning?
No, Your Honor.
Favre, are you aware of any such legal reason?
I am not, Your Honor, no.
Mr. Valonga, are you aware of any legal reason or any other good reason why we shouldn't proceed further with your sentencing today?
No, Your Honor.
We'll proceed further then. Counsel, I'm not aware that there's been a departure motion or any other motions to take up. Does the state have any such motions to pursue?
None, Your Honor.
Does the defense, Mr. Favre?
No, Your Honor.
Are there any victims and members of a victim's family present who desires to address the court in relation to this sentencing?
Yes, I'm
Okay.
his mother,
All right, state your name, please.
Joanne Corcoran.
What is your statement to the court?
Well, can I address this to my son?
You may.
First of all, I'd like to tell him that I love him and my heart is broken and that he is in my prayers every day. And I want him to know that I have wrote a note to Judge Rickey asking him to sentence you to the full extent allowable by law, to give you a chance to overcome your addictions, to better your life, and to find a way to become an honest and stalwart young man. And that is what I hope and pray for you to become, son. The other thing I want you to know that is I'm going to leave the no contact order in effect until your sentence is completed, because I feel that I'm a detriment to you becoming the kind of person that you need to be. Even though I love you, I think I help you too much, and you need to find a way to be that person on your own. And that's all I have to say.
Honestly, she is doing her son probably the biggest favor of his life.
Very well. Thank you, ma'am. Noting there does not appear to be any other participants who desires to address the court. This time, the court will ask counsel for their recommendations regarding an appropriate sentence, beginning with Brett Sweeney on behalf of the state of Kansas.
Thank you, Your Honor. Your Honor, the plea agreement in this case contemplates a state recommendation, and the state would go ahead and recommend 8 months in the Department of Corrections, which is the standard in mid-box. The state is recommending he would qualify for a maximum good time percentage of 20% and have a post-release supervision duration of 12 months. He does have 67 days of jail time credit. I would note that
does he, Mr. Sweeney?
Yeah, I was getting to that. I think he's got a sanction out of that 24 CR 59 case. But I think the way that I currently construe the way jail time credit is being calculated through the appellate courts in the state, that I think that I was looking at that this morning. I think it would still qualify unless the court ran this case consecutive. And then I think, so I guess it's kind of contingent maybe on what the court is going to do with this case. And the state is asking that this case run consecutive to 24 CR 59. So I think it's kind of, like I said, contingent on whether or not what the court does with this case as opposed to that one.
Ooh, you may not want to put this in Judge Ricky's hands.
So I guess I'll just leave it there. As far as where he's at, as far as presumptive probation, it looks like now there's 2 boxes marked, Senate Bill 123 mandatory and Senate Bill 123 with the court finding. It does look like he does qualify for Senate Bill 123 because he's got the high probability of a substance abuse dependency, and he's got the high scores there. So the state would acknowledge that it looks like he's going to be Senate Bill 123 eligible through the amendment in the statute that allows for non-drug cases to qualify for that. The state would ask that he be placed on up to 18 months of community corrections probation. State would ask for all of the conditions that are listed within the PSI to be adopted. I think they're all appropriate, including, I guess, specifically no contact with his parents, Darren and Joanna Corcoran, or their property. I would also note that there's a request in the PSI for an educational component. That's not always standard, but I guess education or a job or something he probably should be doing. As far as costs and fees associated with the case, I noted that in the state's file, there's a request from Ms. Corcoran for $8,650 in restitution. State would make that request. It looks like for some French doors, I know those can be expensive. State's not requesting a fine. We are requesting the court costs on the matter, supervision fees, community corrections fees, $300 payable towards the Senate Bill 123 evaluation, and then treatment. It looks like there's a recommendation for an intensive outpatient component, at least initially. State would be requesting attorney's fees if they're appropriate as well. I think that's all I have in the way of recommendations to the court, Your Honor. Thank you.
Thank you, Mr. Sweeney. Mr. Favre, your recommendations regarding an appropriate sentence?
Judge, just to touch on some of the issues that Mr. Sweeney raised with the PSI, I think 8 month standard is fine. I think that it is mandatory, Senate Bill 123, as I understand the statute. I'm not sure it's with court finding. I don't know why that box is checked, but I think he does qualify for mandatory based on my understanding of the expanded SB 123. In regards to the jail credit, it's still a little murky to me, but as I understand that Hopkins case, he should get credit for 67 days on this case. I'm not 100% sure, to be frank with you, because in 24 CR 59 we had agreed to do a 60-day sanction as part of that case as of November 1, which would have definitely given him credit for that case. So anyway, that Hopkins case seems to say that he gets credit for all his time incarcerated. That's what I understand it to say.
Even when it's mandatory consecutive, Mr. Favre?
Well, that's a good question, and I don't really know, Judge. I guess, yeah. I would say if I had to say, I would say that the credit should go for sure first to his probation violation case, the warrant to show cause, and then any remaining time, if it's mandatory consec, would go to this case. I think that makes sense to me. But that again, that Hopkins case kind of murkies it for me a little bit, so I'm not 100% sure. In regards to the recommendations for the in the PSI for the conditions of probation, we have no objection to the standard conditions. I've spoken to Mr. Vayamunga about his plans. He does plan to go to drug treatment. He does plan on living at a sober living house. He currently has his girlfriend looking for places he can live in a sober living house, as well as he has opportunities for employment lined up as a server in a restaurant. So he is making some plans once he's released. So other than that, we have no other recommendations.
Very well, Mr. Favre. Court will address the defendant personally, and I'll ask him if he has any statements that he wishes to make in mitigation of punishment or anything further that he would like to present to the court.
Really, the only thing that I would like to say is whatever sentence or consequence that I get, I know I deserved, and I'm just ready to either get out or serve my time and then get on with my life. Honestly, I never imagined that I would spend half a year in jail as a kid, and going through it, it's not really the person that I want to be or continue to be. So.
All right. How do you compute that you've been in jail for half of a year?
Well, I did 100 days in the beginning of the year, and then a couple months later, I did about a month, and then I've been here for about 2 months.
Okay. Anything else?
No, Your Honor, that's it.
We'll pronounce sentence in this case at this time. Court hereby establishes count 1 as the base sentence in the case for the offense of attempted residential burglary, a severity level 9 non-drug person felony, in which the defendant has a criminal history score of G, thus placing him in grid box 9G. The court hereby sentences the defendant to the aggravated term of 9 months in the custody of the Secretary of Corrections of the state of Kansas. On this sentence, the defendant may earn up to 20% of good time credit and would be subject to 12 months of post-release supervision. The court has considered but declines to impose a fine in this particular case. Court does find that in grid box 9G, normally this would be a presumptive probation case. However, I will note the application of a special rule that this defendant was on community corrections at the time the offense was committed, which would enable this court to impose a prison sentence in this case. And in fact, Mr. Valonga, it would left to the court's sole discretion. That's exactly where you probably need to be. But there is an overriding statutory scheme here called Senate Bill 123 that's been expanded, as I think has been alluded to include cases such as yours. And the court finds that based on the substance abuse assessment, which finds that this defendant has a high risk of a substance abuse disorder, and that he has high risk, high needs on his LSCMI.
Now, keep in mind, he was under Senate Bill 123 the last sentencing that we watched for the robbery of the liquor store.
That he is a mandatory case for Senate Bill 123. And therefore, the court will be placing the defendant on community corrections supervision and probation for up to 18 months with a specific requirement that he successfully complete a substance abuse treatment program and any aftercare recommendations which are made in accordance with that program. In other words, Mr. Valonga, Senate Bill 123 has saved you from a prison cell today.
Yes, Your Honor.
But it's be focused on getting yourself substance abuse treatment and staying away from drugs. I don't know if you can do that or not. I wish you luck. I hope you can. But you are required to do so here. Other conditions of your probation will be reporting to an officer as directed, observing all laws. You shall not possess or consume alcohol or illegal drugs while on probation. At the supervising officer's request and at your own expense, you shall submit to random breath, blood, and urinalysis testing, perform community service work pursuant to program requirements, gain and maintain employment throughout your probationary term, notify your supervising officer of any changes in employment status, residence, telephone number, or email address within 24 hours of any such change taking place. You shall have no contact with the victims Darren and Joanne Corcoran or their property as a condition of your probation. You shall complete a GED educational program as part of your requirements. Abide by any curfew and travel restrictions imposed by your intensive supervision officer. Follow all standard conditions of probation. Not have in your possession firearms or dangerous weapons. Avoid disreputable characters and places. Not to have possession or use of any marijuana variants. Make monthly payments in a manner acceptable to the court. And follow all Senate Bill 123 rules, recommendations, and requirements. The court will be assessing felony docket fee, felony probation fee, community corrections fee, $300 reimbursement in Senate Bill 123 costs. Court will order the defendant to pay $8,650 in restitution. I believe that's all due and owing to the Corcorans. All bids assessments will be waived in light of the amount of other assessments already ordered by the court. Quite frankly, Mr. Valonga, it's the intention of this court to have you serve an additional 60 days in the county jail as a condition of probation. I do note that there is this Hopkins issue, this how to apply previously served jail time. The court finds it inconsistent with justice for you to receive dual credit. Since this court is going to be running this case consecutively to Butler County Case 2024 CR 59, you've been serving sanction time. It's the court's understanding for all 67 of these days. You were probably held prior to hearing on your 59 case. Then you had a 60-day sanction ordered. It would appear that all of this 67 days very well may be attributable to the 59 case, and you shouldn't get dual credit. You need to do time in regards to this case. This case in and of itself is serious. And the court just finds it inconsistent with the interest of justice for you to receive dual credit for time that you shouldn't receive dual credit for. Okay, did someone speak up a moment ago?
I did. I do understand that. I was under the impression that I was serving time for this case at the moment.
Why would you think that? You've been under bond in this case, I think.
Yeah.
Okay. Well, I'm ordering 60 more days for you.
Okay.
And quite frankly, that 60 days begins when the sanction period ends, which I don't think has expired yet.
I don't believe so. I believe it ends tomorrow.
Yeah, I think that's right. Then 60 days beyond that. This was a flagrant set of circumstances in this court's view. Reading the victim impact statements, ripping off your own parents, damaging their property, shows a total disregard for not only any type of family values, but this is the actions of someone who just doesn't care about following rules and doing what they're supposed to do. And while the court can't impose a prison sanction today, because of the Senate Bill 123 application, certainly the court believes that 60 further days in the county jail are appropriate. And again, running consecutively to any time credited in 24 CR 59. You'll need to contact Community Corrections immediately upon your release. I think after this hearing is over, we're going to leave the meeting open so that you can visit with Mr. Klossing from Community Corrections. He may give you some additional information or direction about what you need to do when you get out. Court has some further orders that it needs to make at this time.
As Catherine Gaston says, night shift gavel drops.
At this juncture, subject to correction, court grants no jail time credit. On this case, it appears that all time very well should be credited solely to 2024 CR 59. Mr. Valonga, you may have the right to seek expungement of this offense in the future. Certain statutory limitations do apply. If you have any questions about your right to someday seek expungement, you can address those to a lawyer and I'm sure get your questions answered. Under certain limited circumstances, a criminal defendant has a right to appeal their conviction to an appellate court having jurisdiction. And if they are unable to pay the cost of an appeal, the defendant may request the court to appoint a lawyer to represent them on appeal and that to direct that they be supplied with a transcript of trial court proceedings. Pursuant to KSA 223608C, a defendant has 14 days after this judgment in court to file any notice of appeal with the clerk of the district court of Butler County, Kansas. You do have the right to appeal this sentence if the court has ruled adversely to you at this hearing. I will remind you that there's prohibitions against a convicted felon possessing a firearm, that there are losses of certain civil rights, such as the right to vote, until your sentence is fully discharged. I am hesitant to try to set a minimum payment requirement for probation. I usually try to give Community Corrections some direction there, Mr. Klossing, but I think you're just going to have to sit down with him and analyze his then financial circumstances and come up with a reasonable amount for him to pay on a monthly basis. I am going to declare the entire amount due and payable. I'm looking at my notes from this sentencing. Mr. Klossing, do you need any further direction from the court regarding probation orders?
No, Your Honor.
Okay. Mr. Sweeney, is there anything else that the court needs to address?
No, Your Honor.
Mr. Favre, anything further?
No, Your Honor.
Mr. Favre, I made that earlier jail time credit order with the suggestion that is subject to future correction. If you can find some applicable law which requires this court to give him dual credit for the time previously served, the court obviously will consider that.
Thank you, Judge.
All right. Thank you for your work on the case, Ms. Teal. All right. Mr. Valonga, I just want to tell you that you don't have unlimited chances on this. If you think you're going to get multiple opportunities to prove to the court that you're going to do in the community what you were supposed to do, I think that you'd be very mistaken. You are on the very precipice of just going to prison. If you want treatment, if you want help, if you want to stay out in the community and not go to a prison cell, then you're going to have to follow the rules. Good luck in that regard. I truly hope you make it.
Thank you, Your Honor.
All right. If there's nothing further, then this matter is concluded at this time. We'll recess proceedings, but we'll leave the meeting open so that Mr. Klossing can visit briefly with the defendant in this case. All others can leave the meeting if they so desire.
I still say his mother did the best thing for him. He's not going to get the help that he needs with her always giving him a place to run to. It's not helping him. They always talk about having to hit rock bottom, and maybe she's helping him get there faster. And yeah, with as far as your comment, Jess, I think, I don't really think that Judge Ricky is such a fan of the treatment programs there. He called Senate Bill 123 a scheme. That's kind of telling. Oh, there's always a mental health component, I believe. I've said it before. I don't really think that there's as big of a drug problem as there is a mental health problem. Yeah. I really hope he's successful. I don't wish negativity on anyone. I want the best for everyone. And it's heartbreaking to see someone in that position going through addiction. I mentioned it in the chat, but I literally just had someone that I was very, very close to that had to pack up and, well, not even pack up. I mean, they kind of just got in a car and left and went out of state for an inpatient treatment, but I'm cutting them out of my life. I have to. But the last night here, they were on something very severe, actually. The same thing that they've talked about in the cases tonight. And it was a bad batch. And it's someone who had been sober for 11 months. And they relapsed. So that was so hard to watch. I had never seen someone in person on it. I've seen body cam videos of it, but it's different when they're sitting next to you in that state. It's different and it hits. But we got a hold of their NE sponsor and they drove a few hours to get them and away they went. So I hope that they're successful in kicking their addiction as well. But I can't go through that again. I can't. It broke me. But if I hadn't gone and gotten them, I don't know that they would have made it through the night. So, but anyways, sorry, I didn't mean for that to get so heavy. But yeah, I really hope that kid's able to go through the treatment program, take it seriously, and get through it. And Mortimer Duke wanted the spelling of the name. Purely for educational purposes, I am sure. I couldn't look it up while the case was running because my computer just can't handle that. Hold on. He said for $5. For $5, if I provided the correct spelling of the name. It is. Let's see here. Here we go. All right. Mortimer Duke. VAIOMOUONGA, and I am not kidding. I was following it for a while. I had a few of his cases saved up on the Avid drive. I love you so much. I know you were, which is why it made it so much more funny. I wasn't expecting you to actually do it. I can't. It's up to you now. I had to read it. All right, guys. There, he went back for it. I couldn't pronounce it for the longest. I couldn't. I tried. I don't even, I still. Valonga? I think that's how it was. I really like it. I wouldn't want it for my name, but I really like it. Not such a fan when people name their child King. That one I'm just not great at, but I really do like that last name. It sounds I don't know, it sounds regal in another way, you know? And on that note, oh my goodness, why? Why do you do that to me? Why? The last thing I want to imagine is Jay Regier in the throes of passion. Jess, you signed up for this. You joined this. All right, guys. Thank you so much for coming and hanging out with me tonight. That was so much fun. I can't now. Thanks a lot. You tainted my brain. Yeah. Oh, I love you guys all so much. Oh, I don't know what I would do without you. Be safe, be well, sleep sweet, and much love.